Welcome to the joint meeting of the Assembly and Senate Committees on Legislative Operations and Elections. Thank you, everybody, for your flexibility and patience today. Will the Secretary please take the roll?
Senator Daley. Senator Cannizzaro. Senator Krasner. Senator Steinbeck. Chair Orenshaw.
Present.
Assemblymember Cole. Dickman. Edgeworth. Gonzalez. Hibbets. Howdigi. Miller. Monroe Moreno. Moore. Nadeem. Chair Mosca.
And I am here. May we please mark the following senators, Senator Daley and Senator Cannizzaro present as they arrive, and for Assembly members, Assemblymember Cole, Vice Chair Gonzalez, and Assemblymember Moore. Oh, sorry, Cole is here. My apologies. I got it. Gonzalez and Moore, thank you. And Dickman, okay, and Assemblymember Dickman, thank you. Okay, thank you, everybody. Welcome to the audience here in Carson City for round 2 for the Assembly side, those joining us in Las Vegas, as well as those listening over the internet. Before we begin, I'll make several housekeeping announcements. Please silence your electronic devices. If you wish to testify, please sign in at the table by the door and provide a business card to the committee secretary. When testifying, please turn on the microphone and clearly state and spell your name for the record and any affiliation. There are hard copies of the meeting materials available for members of the public, and members of the public may also access electronic copies of the materials on the Nevada Legislature's website. Public comment will be taken at the end of the meeting and can be on anything in the purview of legislative operations and elections, but not on anything we've heard today. Each person will be limited to 2 minutes. In addition, the public may submit written testimony to the committee up to 24 hours after the meeting. Very importantly, we expect courtesy and respect in our interactions during the meeting from those of us joining us, from our own members, and even if we don't agree with one another's position. And as we are close to ending session, this is even more important, so we'll be monitoring that today. And finally, committee members will be using their laptops to view handouts and other documents, so do not view this as a sign of inattention or disrespect. We also have members going in and out that are presenting different bills. So with that, we will be going in order of the agenda today. So I will open the hearing on Assembly Bill 595. This measure revises provisions governing fiscal information for legislative measures. And we have our very own Assembly member Monroe Moreno and Ms. Sarah Kaufman from LCB Fiscal presenting today. So as a reminder, you will have 15 minutes and you may begin when you're ready.
Good evening, Chairs Mosca and Orenshaw. For the record, I am Assemblymember Danielle Monroe Moreno, and I proudly represent Assembly District 1 in Southern Nevada, and I serve as the chair of the Assembly Committee on Ways and Means. Today, I am presenting Assembly Bill 595 that would simply clarify the definitions of executive budget in statute as it relates to drafting legislation and obtaining fiscal notes. Joining me here at the table tonight is the Ways and Means Chief Fiscal Analyst, Ms. Sarah Kaufman, who is nonpartisan LCB staff to assist with any technical questions. Currently, the State's Budget Act, and more specifically NRS 353.230, outlines the requirements for the governor to submit a recommended budget for an upcoming biennium. This includes the various documents, files, and legislative measures needed to implement the executive budget. Along with the governor's requirements for preparing the executive budget, various requirements for drafting legislation and obtaining fiscal notes based on the executive budgets are detailed in Chapter 20 and 218D of the NRS. This includes noting on a bill if funding is included in the executive budget and not requiring a fiscal note if a bill is exclusively related to the executive budget. Chapter 218D of NRS does not reference NRS 353.230 directly in terms of the definition of the executive budget, sometimes leading to ambiguity regarding what is and what is not included in the executive budget. To address this, Assembly Bill 595 contains in Section 1, which would clarify the executive budget as defined in NRS 353.230, is the basis for determining whether funding is included in the executive budget as Legislative Council Bureau staff draft legislation. Section 2, which would clarify the executive budget as defined in NRS 353.230, is the basis for determining whether a fiscal note needs to be obtained by Legislative Council Bureau staff. I've come before this body before a few times this legislative session, and I said that as chair of Ways and Means, I knew we weren't going to have a ton of money this legislative session, but we still had opportunities to do some really great work in this body. So a number of pieces of legislation you've had to consider that are kind of like cleanup and modernizing what we do as a legislative body to make the work that we do more effective and more efficient, and that is what Assembly Bill 595 does. So we thank you for your time, and we stand for questions.
Thank you so much. With that, we do have some questions, so we will start with Assemblymember Cole.
Hello, thank you so much for this. And thank you, Chair. So my question is just, can you give maybe a couple of examples? Maybe not even examples. How much bigger will the executive budget be based on this, if that makes sense? Like there's ambiguity there. Will a lot more be included in it or no?
Danielle Monroe Moreno for the record, and I'll start and then I'll hand it off to Ms. Kaufman. It won't affect the size of the budget per se, but timing and things. You know, the governor's office has so many days that they can present amendments and things to us. That's in statute. This will help clarify that. This is my fifth legislative session and my fourth session on Ways and Means, and we have had more amendments this session than we have ever. And coming in later and later and later, it makes it difficult for us to do the work that we need to do as a body. So when we're presented with that, I call it the governor's wish list, when we get the budget at the state of the state, it is our job as a legislature to take that budget and make sure that it addresses all the needs and fits within the parameters of the finances that we have as a legislative body. And it just clarifies that. The only way that we can make it bigger is if we get more resources, so.
Thank you very much. Any follow-up, Assemblymember Cole? No. Members, any additional questions for our presenters? Okay, I'm not seeing any additional questions. Thank you very much for presenting Assembly Bill 595. With that, I would like to go to testimony and support, and I just want to let everyone know that for all three bills on our agenda today, I think because of the time constraints of getting back to floor for the Assembly members and the senators, we're going to allow 20 minutes of support testimony, 20 minutes of opposition testimony, 20 minutes of neutral testimony. So for each bill, that's kind of the lay of the land. And if you don't get a chance to speak or call in, written testimony will be made part of the record. So please submit your written testimony for any reason you don't get a chance to speak. So on Assembly Bill 595, anyone who wishes to speak in support, either in Carson City or in Las Vegas, and not seeing anyone come forward, broadcasting anyone on the phone lines who wishes to speak in support of Assembly Bill 595.
To testify in support of Assembly Bill 595, please press star 9 to take your place in the queue. Again, press star 9 to take your place in the queue. We have no callers wishing to testify in support.
Thank you, broadcasting. I'd like to now go to opposition. Anyone who's opposed to Assembly Bill 595 and wishes to be heard here in Carson City, down in Las Vegas, Okay, I'm not seeing anyone come forward. Broadcasting, is there anyone on the phone lines who wishes to speak in opposition to Assembly Bill 595?
To testify in opposition of Assembly Bill 595, please press star 9 to take your place in the queue. We have no callers wishing to testify in opposition.
Okay, thank you. Anyone who's neutral on the measure and wishes to be heard, either in Carson City or down in Las Vegas? Okay, I'm not seeing anyone come forward. Broadcasting, anyone on the phone lines who is neutral on Assembly Bill 595?
If you would like to testify in neutral for Assembly Bill 595, please press star 9 to take your place in the queue. We have no callers wishing to provide testimony in neutral.
Thank you. And Assembly member, any closing comments? All right, thank you very much. With that, I'd like to close the hearing on Assembly Bill 595. And I don't know if we have our presenter here. We do for Assembly Bill 600? Okay, well then, please come forward, and thank you for presenting Assembly Bill 600. Good evening, Director. Good evening, Director, Mr. Powers, Mr. Killian, whoever would like to begin. Thank you.
Thank you, Senator, and thank you, Committee, for allowing us to present Assembly Bill 600, which is an act relating to the Legislative Department. I'm Diane Thornton. I'm the Acting Director of the Legislative Council Bureau. I will be walking through sections 1, 2, and 4 of the bill, and then I will hand it off to our General Counsel, Mr. Kevin Powers, and to our Legislative Counsel, Mr. Asher Killian. Currently, the Legislative Council Bureau generates revenue from the sale of certain items, including publications and items from our gift shop. This revenue is deposited in the Legislative Fund for use by the Legislative Department. Section 2 of the bill clarifies that the revenue generated from the sale of food from one of our new legislative cafes must also be similarly deposited into the Legislative Fund. Section 1 makes conforming changes related to petty cash accounts of the LCB to include food and other items. Moving on to Section 4 of the bill, as you may be aware, Senate Concurrent Resolution Number 6 was recently adopted by both the Senate and the Assembly. SCR 6 authorizes the Director of the LCB to acquire a vacant parcel of lot located at 515 South Carson Street. This parcel is directly contiguous to the existing campus and is an opportunity for the legislature to provide more public access to the legislative building. Contingent upon the completion of this purchase, Section 4 will revise the boundary of the legislative campus, which the legislature has supervision and control over, and it will include this new purchase parcel. And Chair, now I'd like to turn it over to our councils. Thank you.
Please go ahead. Thank you, Director. Whoever would like to begin.
Thank you, Mr. Chair. For the record, Kevin Powers, General Counsel, LCB Legal Division. And just so it's clear for the record, ordinarily, obviously, we're a nonpartisan agency and we do not normally support or oppose any particular piece of legislation. However, the statutory limitation on that nonpartisan limitation has an exception, and that's an exception that applies when a bill affects the operations of the LCB or the legislative branch of government. And so that's why myself and Mr. Killian are here today to talk about an important section, Section 3 of the bill, that deals with a recent Nevada Supreme Court case that's cited in the digest of the bill. That case is Nevada Policy Research Institute versus Miller. The citation is in the digest, and that was decided on October 31st, 2024. The issue in the MPRI case was whether the separation of powers provision in the state constitution prohibited legislators from serving as employees in the executive department or with local governments. Now, that decision had two components to it. It had state constitutional interpretation and state statutory interpretation. With regard to state constitutional interpretation, the Nevada Supreme Court is the final interpreter of the state constitution. The legislature, by ordinary legislation, cannot change a Nevada Supreme Court state constitutional interpretation. The only thing the legislature could do is propose a constitutional amendment. This bill is not intended to and cannot change the state constitutional interpretation in the MPRI case. That's not why we're here. In addition to state constitutional interpretation, the NPRI case had a state statutory interpretation component where the Nevada Supreme Court looked at the organization of the titles in NRS to determine whether or not an entity fell within the executive branch, the judicial branch, or then the legislative branch. In particular, the Nevada Supreme Court found that the entity, in that case the Board of Regents and the state university, fell outside all three branches of government. So we're going to focus then on the state statutory interpretation component, because when it comes to state statutory interpretation, the legislature is supreme. The legislature, by statutory enactment, can supersede or override the Nevada Supreme Court's state statutory interpretation. The issue we're dealing with from the case was whether or not the Board of Regents and the state university were part of the executive branch of government. The Nevada Supreme Court looked at that to determine whether or not a legislator could serve in the state university and also serve in the legislature. The Nevada Supreme Court, as state constitutional interpretation, found that the separation of powers provision didn't prohibit a legislator from also being employed by the state university. In arriving at that conclusion, the Nevada Supreme Court looked at Article 11 of the Nevada Constitution, and it said, because of the Board of Regents and the state university's unique constitutional status in Article 11, that the Board of Regents and the state university fell outside of the three departments of state government. Had the Nevada Supreme Court stopped there, I wouldn't be before you right now. That's state constitutional interpretation. The Nevada Supreme Court is the final interpreter of the state constitution, and the legislature, by ordinary legislation, couldn't do anything about that. However, and unfortunately from our standpoint, the Nevada Supreme Court went further, and it said, let's look at where the state university and the Board of Regents are codified in NRS. They looked at the NRS, which is divided by titles and subject areas, and they said there's a general judicial department title, Title I in NRS. The Board of Regents wasn't in that. There's a general legislative title, Title 17 in NRS. The Board of Regents wasn't in that. Title 18 is the general executive branch title. The Board of Regents wasn't in that. Instead, the Board of Regents was in Title 34, which governs education, because the titles of NRS are divided by subject matter, and so it would make sense that the Board of Regents were in Title 34. Unfortunately, the Nevada Supreme Court said because the Board of Regents was in Title 34, it indicated a legislative understanding that the Board of Regents fell out of the three branches of government and acted outside the three branches of government. We believe that's an erroneous statutory interpretation. It's not just the Board of Regents. There's numerous state executive branch agencies whose governing statutes are codified outside of Title I, Title 17, and Title 18. For example, there's a Title 41 governs gaming. You have the Nevada Gaming Control Board and the Nevada Gaming Commission. They're in Title 41. They're not in the general Title 18 chapter for the executive branch. They're in Title 41, but they're still executive branch agencies. You have Title 54 with all the boards and commissions. They're obviously executive branch agencies, but they're not in the general Title 18 for the executive branch. Then you have the Public Utilities Commission in Title 58, the Cannabis Compliance Board in Title 56, again, executive branch agencies whose main statutes aren't in Title 18. Now, at this point, you might think this sounds very esoteric and academic. It's not, because this could have negative consequences on the legislature's oversight and control of executive branch agencies. There are cases in the past where executive branch agencies argued that they were independent agencies outside of the three branches of government. In particular, in 2009, in the case of Commission on Ethics versus former State Senator Warren Hardy, the Commission on Ethics argued that it was an independent agency outside the three branches of state government, and it could exercise control over voting by legislators, which is a core legislative function. In that case in 2009, the Nevada Supreme Court said every state entity must have a primary connection to and draw its power from one of the three branches of government. We agree with that. Every agency is part of the state government, and the Nevada Constitution says there's 3 branches of government: the legislative, the judicial, and the executive. Obviously, the Nevada Supreme Court is the final interpreter of the Nevada Constitution, and they now have determined in this case, which was a 4-3 decision, that the Board of Regents and the State University fell outside of the 3 branches of government. And again, that's constitutional. We're not trying to change that. What we're trying to stop is agencies in the future grabbing on the language from the MPRI case and making their argument that they're independent agencies outside the 3 branches of the government. They make that argument so they can claim independence and autonomy from legislative regulation and control. So with that background in mind, let's turn to the specifics of the bill, Section 3. The first subsection states what we believe is a valid and clear proposition of law. Each state office, agency, court, or other entity must have a primary connection to and be part of one of the 3 departments of state government. And no state office, agency, court, or other entity is created, exists, or functions outside of the 3 departments of the state government. That is a basic proposition of law. We are very comfortable with that. Again, with regard to the Board of Regents and the State University, the Nevada Supreme Court have made their decision. We can't change that constitutional interpretation. But with every other state entity, this is making it clear that every state entity falls within one of the 3 branches of government. Subsections 2 and 3 deal with the process of codification of the NRS and the organization by subject matter. So subsection 2 makes clear that the purpose of NRS organization is to ensure there's a logical and orderly arrangement of the statutes, making it convenient for the reader, and things are grouped by subject matter. But the fact that the Legislative Council, under its statutory authority, has organized the NRS by titles and subjects doesn't mean the legislature has determined to exclude any agency from the executive branch of state government because they're not in the general Title 18 governing executive branch. So subsection 2 deals generally with that issue, and then subsection 3 drives the point home that there are executive branch agencies that are in various titles of NRS, Titles 7 to 12 inclusive, 14, 16, 18, and 22 to 58 inclusive. There are executive branch agencies in all those titles. This makes clear that the decision to put those executive branch agencies in subject matter titles doesn't mean the legislature has excluded them from the 3 branches of government. So that's my general overview. I'll turn it over now to Mr. Killian, who wants to follow up on some of those comments, and then, of course, I will be open for any questions. Thank you, Mr. Chair.
Thank you, Mr. Powers. Asher Killian, Legislative Counsel. Thank you, Mr. and Madam Chair. Kevin got to part of the litigation basis for why this language is in front of you. What I'm going to address is the practical basis in terms of the codification of the Nevada Revised Statutes. The codification and placement of provisions within NRS is a duty that the legislature has given to the Legislative Council. And there are laws in place that specifically guide how the Legislative Council and the Legal Division exercise their judgment to codify NRS. Specifically by law, the legislature has directed us to organize the statutes in a logical order throughout the volumes of NRS, and it has directed us to group subjects of a kindred nature under a single general heading. That is why the Nevada statutes, as opposed to the statutes of some other states, are organized into a variety of titles, all of which are based around a particular subject matter. Not every state necessarily codifies its statutes this way. If you look to our neighboring California, they actually have multiple different codes, each of which has a set of numbering. The practical consequence of this language in the NPRI v. Miller decision, where the court concluded that because not everything is codified into 3 titles, anything outside of those titles must be outside of those departments of government, would be one of 2 things. Either following that opinion, I would be required to recodify all of NRS from its existing 58 titles into 3, with 1 title for the legislative branch, 1 title for the judicial branch, and the entire rest of NRS, almost, in a single title, which would make the statutes monumentally less user-friendly and make the numbering quite complex and difficult to follow. Or we would have to follow a model like some of these other states that have separate codes. So we would have a Nevada Legislative Code, a Nevada Judicial Code, and a Nevada Executive Code, with all of the various titles of NRS reorganized into one of those three codes. It is our belief that either of these approaches would make the Nevada Revised Statute significantly less user-friendly. And since the origin of this direction seems to have been a clear error by the Supreme Court in how it construed the way that things were organized in NRS, we believe the proper solution is to instead add this language to the preliminary chapter of NRS as specified in Section 3 of this bill, to make it clear that these codification decisions are decisions pursuant to the direction that this legislature has given the Legislative Council to organize the statutes by subject matter, and that's why they're divided into separate titles. And to clarify all of the various titles of NRS in which executive branch agencies are located or have their duties specified. And with that, Madam Chair, I believe that concludes our presentation, and we would be ready for any questions you may have.
And thank you so much, and thank you, Chair Ornshaw, for taking over during my bill presentation. I'm glad I got to see some of this, though. So we will start with Assemblymember Hibbets.
Thank you, Madam Chair. I have two, if that's okay. First one, and I'm not sure who can answer this one. I'm assuming Mr. Killian. Section 3, subsection 1, line 35, you use the word at the very end of that line, departments. Is there a reason that the word branches was not used?
Thank you, Madam Chair. Asher Killian, Legislative Counsel, through you to the member. Yes, that's the specific language that's used in the Nevada Constitution. In Article 3, Section 1, the state government is divided into three departments, the legislative, executive, and judicial. Those are commonly described as branches, and branch is the term that we're all used to from high school government class. But here in Nevada, the Constitution specifically uses the term department to describe the branches of government.
Thank you for clarifying that. I appreciate it. And the second one is for Mr. Powers. I assume you'd probably be the one to answer this one. You stated that in 2009, the Nevada Supreme Court in the Ethics Board versus Hardy decision said there were three branches of government. However, last year they completely went against that, their own ruling, and said that there was not three branches of government. At least that's how I interpreted it. And as the dissenting opinion of Chief Justice Herndon said, there must be a phantom fourth branch. What is to stop the Supreme Court from having another, I won't use the term I'm thinking of, lapse of judgment and declaring there's now a fifth branch that this does nothing to do, or does nothing to solve?
Thank you for the question. Obviously, I can't speak to what the court will ultimately do, but I think the focus of the majority in the MPRI case was Article 11 of the Nevada Constitution, and they believe they were creating a carve-out for just the Board of Regents and the State University because those two entities are specifically mentioned in Article 11 of the Constitution, and given a certain amount of, a slice of limited sovereign authority. So they saw that as Article 11 was express language in the Constitution that created the carve-out for the Board of Regents and the State University. Our hope would be that there are no other carve-outs that they'll find in the Nevada Constitution and that they won't go in that direction. But one of the reasons we want the language in the statute is that so that statutorily they don't start saying entities fall out of one of the three branches of government. There are some other entities in the Nevada Constitution, like the Commission on Judicial Discipline. They once argued they were a fourth branch of government. The Nevada Supreme Court said, no, you're part of the judicial branch and subject to the jurisdiction of the Nevada Supreme Court. Not really surprising, but that's what they decided. There are some other state constitutional entities like the Board of Pardon Commissioners, the Board of Examiners. Those are state constitutional entities. They're within Article 5 of the Nevada Constitution, which is the State Executive Department article. And so in theory, they are operating as part of the executive branch of government. I think it's because of Article 11 being separate from Article 4, 5, and 6 that the Nevada Supreme Court, at least four of them, determined that the Board of Regents and the State University fell outside of the three branches of government. I think you can tell from my testimony, As a lawyer, I don't agree with that interpretation, but again, I have to accept it, and we all do, because the Nevada Supreme Court is the final interpreter of the state constitution. Thank you.
Thank you. Next, we have Assemblymember Miller.
Thank you, Chair. Thank you for presenting this bill. And I have a question, and I will use my colleague's terminology. So when it comes to having this phantom branch or department that you will, and again, you're absolutely correct. We all look toward the United States Constitution, which clearly defines 3 branches of government. Are there any other states that have this type of phantom carve-out, self-proclaimed 4th branch happening?
Thank you for the question. In the MPRI case, the Nevada Supreme Court specifically looked at the California Board of Regents, and they cited a California Supreme Court decision that, quote, said that the Board of Regents constitutes a branch of the state itself or a statewide administrative agency with virtual autonomy and self-governance. So that sort of autonomy and self-governance was found in the California Supreme Court case, and the majority in MPRI relied on that. Let me say, though, one of the dissent pointed out, and we cited in our briefing, there are many other states with constitutional Board of Regents that have concluded those Board of Regents are still part of the executive branch. What they've concluded is that the Board of Regents and the executive branch have a narrow slice of sovereign constitutional authority that the legislative branch and the governor can't interfere with, but they're still part of the executive branch. They're not existing in, to quote you, phantom 4th branch of government. Yes, I don't believe we have the multiverse, but some 4th branches of government may exist that we weren't previously aware of. Thank you.
Thank you so much.
Thank you. Next, we have Assemblymember Cole.
Thank you so much. So I just wanted to make a quick statement. So I'm a transactional attorney, and it is common practice for us to include a headings clause where we state that the headings are there for convenience only and don't really change anything substantively. So I see a very direct parallel to that in what you're doing, and so I'm very much in favor. Thank you.
Thank you. Members, any other questions? Okay, thank you so much. Seeing none, we will move into support testimony for AB 600. Thank you so much. And as Chair Orenshaw has shared, because we're all going back to floor later, we are limiting testimony to 20 minutes in all of the different blocks. And don't forget to state and spell your name for the record. I will read out the call-in number one more time. 669-900-6833, meeting ID 821-2679-8649. We'll start here for support of AB 600 in Carson City. Seeing none, we will go down to Las Vegas. Thank you.
My name is John Sarpalis. I'm the president of Nevada Policy Research Institute, NPRI, that you've been hearing about for the last 15, 20 minutes. And we are the ones that opened the door on this with our lawsuit. This is a very simple matter at this point, is we've got to clean this up. There cannot be a 4th dangling participle out there. It has to be brought back into the executive branch. So we urge that you will vote yes on this bill today, because it's just needs to be cleaned up. It's a statutorial problem. The legal problem will happen back through the court system at a later date. If you have any questions, I'm open, and thank you for your support.
Thank you. Next person.
Greetings. My name is Ben Pennington, last name Penninington, speaking today as a private citizen in support. I'm looking forward to seeing you guys get your funds from your snack shop restored. I'd also like to point out to the LCB, Indiana's constitution does provide for a quasi 4th branch of government listed. So in future reference, you might want to, in the event the court becomes a problem, look to the Crossroads of America for future legal writings.
Thank you so much. And seeing no others in Las Vegas, AVH will open up the phone lines for support of AB 600.
To testify in support for Assembly Bill 600, please press star 9 to take your place in the queue. Again, if you wish to testify in support, please press star 9. Chair, the public lines are open and working. We have no callers choosing to testify in support.
Thank you so much. With that, we will hear testimony in opposition to AB 600. We will start here in Carson City. Seeing no one coming to the table and no one in Las Vegas, AVH will go back to you for opposition to AB 600.
To testify in opposition to Assembly Bill 600, please press star 9 to take your place in the queue. Chair, we have no callers for opposition at this time.
Thank you so much. And with that, we will move to neutral. If you are here for neutral testimony on AB 600, we will start here in Carson City when you are ready. Don't forget to state and spell your name for the record, and you'll have 2 minutes.
Kent Irvin, K-E-N-T-E-R-V-I-N, Nevada Faculty Alliance. I am certainly not a lawyer, and I just have a point of information. A couple of years ago, I had occasion to do a fairly thorough search of Board of Regents minutes and legislative records for Fourth Branch, referring to NSHE. I found numerous citations of NSHE, or the university system, whatever it was called historically, by members of the public, lobbyists, and legislators, and none from university system personnel. I only found general counsels and others from the university system denying that they were a fourth branch of government. And there was, I think, one instance of fourth branch in the Board of Regents minutes referring to other people referring to them as a fourth branch. Thank you.
Thank you. Seeing no others in neutral here in Carson City, we'll go to Las Vegas. And seeing no one come to the table in Las Vegas, AVH will open up the phone lines for neutral to AB 600.
To testify in neutral to Assembly Bill 600, please press star 9 to take your place in the queue.
Good afternoon. My name is Oscar Williams, O-S-C-A-R, W-I-L-L-I-A-M-S, from Reno, Nevada. I speak to neutral on this, partly from my naivete. I now realize that the LCB is selling souvenir items. I didn't know that before. And with that comes a few questions. For example, what is the revenue from the souvenir sales? Do you have any examples or samples of the souvenir items, particularly the wine or precious metals, maybe coins? I'd like to know. What are the number of products for sale as souvenir items? And of course, the last one, are they made in Nevada? Thank you very much for your time.
Thank you, Mr. Williams. AVH next caller, please.
Chair, we have no more callers for neutral.
Thank you so much. And with that, I will invite our bill sponsors in case they'd like any closing remarks. Seeing none, we will close the hearing on AB 600. Thank you so much. And with that, I will now open the hearing on Assembly Bill 597. This measure revises provisions relating to elections. We have Speaker Yeager here presenting AB 597 today. As a reminder, you have 15 minutes for your presentation before we get to questions, and you may begin when you're ready.
Good evening, Chair Mosca, Chair Orenshaw, Vice Chair Gonzalez, members of the Joint Assembly and Senate Committees on Legislative Operations and Elections. My name is Steve Yeager. I represent Assembly District 9, which is down in southwest Las Vegas, and I want to thank you for the opportunity to present Assembly Bill 597 to you this evening. This is a bill that strengthens our democracy and brings our elections closer to the people they're meant to serve. Nevada is a state of growing independence, not just in spirit, but in voter registration. Today, nearly 1/3 of Nevada's voters have no party affiliation. And as more and more Nevadans are registered to vote through our automatic voter registration process, that number is sure to grow. What you have in Assembly Bill 597 is not a partisan idea, it is a Nevada idea. It's about fairness, transparency, and trust in our electoral system. And most importantly, it is a bill and policy written by Nevadans, not out-of-state billionaires that look at our election process as a playground in which they can experiment. As we all saw the last two elections, billionaires have attempted to exploit the lack of access to primary election for unaffiliated voters as an opening to introduce bizarre concepts like jungle primaries and voting methodologies that require a math PhD to understand. Yes, I'm referencing question 3, and even though question 3 was defeated at the ballot in 2024, we know that they will continue to attempt to exploit this issue to fool around with our elections. That is one of the reasons why I'm bringing Assembly Bill 597. Now, to be clear, because I've gotten a lot of emails in the past few days, Assembly Bill 597 is not the same as question 3 that was defeated at the ballot last year. Chair, I did submit an exhibit, and you should have that available on Nellis and members of the public too, but it provides the full text of question 3 that was on the last two ballots. Let me speak for a moment about that. First of all, question 3 would have been a constitutional amendment. So had it passed, it would have gone into our state constitution, greatly limiting what we could do as legislators to change that. In addition, question 3 put all candidates of all parties into a primary election, and every voter would vote in that primary election, with the top 5 moving on to the general election. That's what question 3 proposed. That's what's known as a jungle primary. Everybody gets in the jungle together, everybody votes, and the top 5 move on. Then question 3 would have said, in the general election, voters would have had to engage in ranked choice voting, where they rank the candidates 1 to 5 or 1 to 3 or 1 to 4, however many made it out. Could have been fewer than 5 that entered the primary. I believe that framework would have been a disaster for our state for a number of reasons. And I think the voters agreed. Now, the question did pass in 2022. It did not pass in 2024. But I want to remind you all, because I think all of you probably paid more attention to election mailers and commercials than most people did. The proponents of question 3 only talked about the open primary part of the question. I don't remember ever seeing an advertisement where they talked about ranked choice voting. The opponents of question 3 only talked about ranked choice voting. I don't remember seeing any of them talk about open primaries. Now, you just heard a constitutional analysis in the bill before. I don't believe those two questions should have been on the ballot together. The Supreme Court disagreed and allowed those two questions to be on the ballot. But I do believe, had that ballot question only been about open primaries, I believe it would have passed. I believe it only failed because of ranked choice voting, and indeed, that's why I opposed it. I think ranked choice voting is a bad idea for the state for a number of reasons. But I just want to make clear that what you have in front of you is not question 3. AB 597 is much simpler. It is a common sense attempt to allow unaffiliated voters to vote if they choose in one of the major parties' primary elections. This bill does not tell voters how to vote. It simply says that unaffiliated voters are able to choose whether to vote a Democratic Party primary ballot, a Republican Party primary ballot, or to continue to vote only on nonpartisan races in the primary, as is currently the law. Now, critics may argue that this threatens party integrity. I respect that concern, but I disagree with it. Parties are not weakened by participation. They are strengthened by it. Allowing non-affiliated voters into primaries does not dilute party values. It ensures that those values are debated openly and broadly. It invites more people into the process rather than pushing them away. We live in an era of cynicism and disconnection from government, and we have seen out-of-state interests attempt to exploit this for their own purposes over and over again. This is our opportunity to push back and offer a solution written by Nevadans that works for Nevadans. It's not just good politics, it is good public policy. Chair, I wanted to highlight 2 amendments to the bill. You have these in conceptual form on Nellis. First, in order to align the timeline in this bill with the timeline in Assembly Bill 148, which was a bill sponsored by Minority Leader Hafen, and which I co-sponsored, and in fact, I just signed that bill today, so it is on the way to the governor. And we want to align the time frame here so that we're requiring unaffiliated voters to request a partisan mail-in ballot by the 7th Monday before the election, which is what's stated in Assembly Bill 148. If they decide and wish to vote in a partisan primary after that date, that is perfectly fine, but they will need to go vote in person at an early vote or election day site. Additionally, I am removing the presidential preference primary from this bill to more align with the model we are working off of, which is Arizona's process, which also excludes their presidential preference primary. Arizona has had this model of voting for approximately 20 years. Chair, there's not much else to the bill, and I know time is short, and we still have to get to floor, at least the Assembly members, so I will conclude my remarks there. I'm just incredibly grateful that you would take time this evening to hear this bill, and I look forward to answering any questions.
Thank you so much. We appreciate that. And with that, we will open it up to questions. Members, I'm sure we have a lot of questions. Assemblymember Cole.
Thank you. So I remember having lots of conversations with voters on this, right? And the concept of the jungle primary was a problem, and having the ability to go in and get a ballot that is Republican or Democrat, it sort of is similar to the ability to do same-day voter registration changes, and then you go back to what you were. But I think the thing that this still doesn't address is, a primary election is for the Republicans or the Democrats to select amongst their own group who they want to represent them in that election. So, what are your thoughts on that? Thank you.
Steve Yeager, for the record, through you, Chair, to Assemblymember Cole. Thank you. I've heard those concerns, and I respect those concerns. I guess I would say a couple of things. Sure, we have same-day voter registration. People can go change their party registration the day of a primary if they want to be Democratic or Republican. I think that just practically doesn't happen, right? We know how the real world operates. People are not going to change party registration and then changing back. They're nonpartisan for a reason or non-affiliated for a reason. Sometimes that's automatic voter registration. That's what they get sort of selected into. And probably, like you, there were people that you talked to that didn't realize, they thought they were registered as something else and they weren't. But, to that point, I guess one of my main concerns here is, number one, the nonpartisan bloc is going to continue to grow. We know that. I mean, it is the biggest party in Nevada now. It's not a party, but it's the biggest block of voting. And I really do believe that, we could choose to say we're not going to do anything about this issue. It will be forced upon us, and it will almost certainly be forced upon us as a constitutional amendment. And what I fear is exactly what you talked about. We're going to end up with a jungle primary, something that I think really is confusing and doesn't make sense. I will acknowledge that as someone who's been serving in office since 2016, sometimes I think as incumbents, we think, well, we don't want to make any changes, right? Because we got elected under this system. And so it's always hard for us to do that. And I think change is hard, but I think it's coming no matter what. And so the way that I view this is, we can put our heads in the sand, but something's going to happen and we're not going to have control over it. And once it's in the Constitution, it's a 5-year process to change it. So I think this is our opportunity to recognize that. I mean, I think the concerns on the other side are certainly legitimate, and I think it's up to the members of this committee and this body to decide, is this something we want to get out in front of, realizing that, some voters may not like it. Although I think if you ask most nonpartisans, they would like to be able to vote in a partisan primary. When you tell them they have to go change their party registration, they're not as excited about that.
Thank you. And thank you, Mr. Speaker, because I would say in my own experience, when I talk to my friends or my colleagues, they are surprised that they can't actually vote in the primary. And I know you said that unaffiliated nonpartisans are the largest. For the record, do you know the percentages of how large they are?
Steve Yeager for the record. So my comments have here is that they're nearly 1/3. I think they're probably approaching about 1/3, but remember, we don't have Democrats, Republicans, nonpartisans, no political party, libertarians. I'm forgetting some others. I know there's probably some behind me that are registered as different parties, but so about 1/3. But they are the largest voter share right now, bigger than Democrats, bigger than Republicans. And to me, we're at a moment where there's a groundswell, and this dam is going to break one way or the other. And so, are we going to be part of that process, or are we just going to let something happen?
Thank you. Next, we'll go to Senator Krasner.
Thank you, Chair Mosca, and thank you, Speaker Yeager, for your presentation. So a couple things. First of all, I absolutely agree with you that we don't want out-of-state billionaires controlling our elections. The people of Nevada want to feel that their vote counts and is important, and they get to choose who they want representing them in their government. So I totally agree with you there. And I did receive numerous emails also, probably the same ones you received, stating that people felt like this is very similar to ballot question 3 that was defeated in November of 2024 here in Nevada. So the concerns I'm hearing when I talk to constituents and other people, other voters, they're saying, Lisa, we became a Republican because we feel that our views align with the Republican Party. Or Lisa, we became a Democrat and registered as a Democrat because we feel that our views align with the Democrat Party. And they feel that allowing nonpartisan voters to vote in primaries will somehow dilute the strength of their vote to choose who they want to represent them and most aligns with their values, whether it be Republican or Democrat. So what are your thoughts on that, please, sir?
Steve Yeager for the record. I'm sure we have been getting a lot of the same emails on this topic. And, look, I respect that, right? I mean, I think if you are, a staunch member of a political party, you are affiliating yourself with an idea. And I think there's value and merit in wanting to protect that. So I cannot dismiss those concerns. I think they are legitimate. But I also think we have to realize that over 1/3 of our voters in the state are not affiliated. They don't want to be either they don't want to be part of a political party, or they were automatically registered as voters somewhere and they went into nonpartisan. So they've either self-selected out of being affiliated with the party, or that just sort of happened automatically. And so I guess what I would say is that feeling is legitimate, but a growing number of our citizens don't share that opinion. And I think you've talked to folks too, like folks, and this is perhaps an indictment of both political parties. I mean, I think both parties are suffering to some degree where folks don't want to be seen as a Republican or a Democrat. They want to be independent, and that really comes out as nonpartisan. And so, those concerns are legitimate, but what do we say to those folks who say, I want to participate in a primary? For instance, if you live in a very Republican or very Democratic district, I mean, the primary is the entire election, right? I mean, and they're shut out of that in our current system. And we can say to them, well, your remedy is to register with one of the parties, but they don't want to do that. And so, I think there's a tension there, and they're both legitimate feelings. And so we as policymakers have to decide, are we going to do anything about that? Should we do something about it? I think we should, because I think we're only going to see those numbers increase. I mean, it is unsustainable in some fashion. I don't think it's out of the question in a decade that over 50% of the voters in this state are not affiliated with a major political party. That's power. That's numbers, and something's going to be done about it. And so, I guess I would just recognize that those concerns are legitimate. I would recognize that change is difficult for everybody, including myself, but we as policymakers have to stand up and say we think this is the right thing to do. And I'm not trying to convince any of you. I'm making the case, but you're going to have to decide whether you think that's the right thing to do. And I really, really do fear, because of how small Nevada is and because of how easy it is to get ballot questions in this state, that something's going to be forced on us that is far, far worse. So if you're concerned about having nonpartisans vote in your primary, how do you feel about having a jungle primary with 5 candidates advancing and then a ranked choice option? I mean, I think that's far, far worse. It doesn't cost a lot for someone to get that on the ballot, as we saw in the last couple elections. And, I don't know about all of you, but I kind of thought that question 3 was probably going to pass this last time because it passed in 22. And it didn't lose overwhelmingly. I think it lost by a few percentage points. So I know that's a very long-winded answer, but, I think those concerns are legitimate, and we just have to decide whether we want to lead the state in this direction or whether we want someone else to come in and do it.
Thank you. Assemblymember Hibbets.
Thank you, Chair. Good timing. Speaker, you testified earlier that question 3 was, the proponents of question 3 only advertised it as open primaries, but it was defeated by 6 points. And the voters had their say. They shot it down. They didn't want it. So why do we need to bring this and override the will of the people?
Steve Yeager for the record. And before I answer that question, Assembly Member, I had a note here passed to me by the Secretary of State that 34.5% of voters are non-affiliated and nonpartisan. So a third was a good answer. 34.5% is a better answer. So thank you to the Secretary of State for that. I've gotten that question a lot in emails, and what I would say is I don't see this as overriding the will of the voters, because how can we possibly know why a voter voted no on question 3? Because there were 2 distinct concepts in there. And again, I don't think they should have been together. They should have been separate questions. But the Supreme Court disagreed with that argument. And, I guess the truth is we don't know if it had just been the jungle primary portion or it had just been the ranked choice voting. I don't know what would have happened, but I'll reiterate that this concept here is not the same that was in question 3 when it comes to the primary. A true open primary was what was in question 3. Anybody could be in the primary, no matter what your party was, including nonpartisans, and anybody would vote in that primary. There was no sort of self-selection. So I see this as a very limited concept. It is not an open primary. It is a primary in which non-affiliated voters can participate in if they choose. So I think this presents a different question. If this question went to the voters, not sure what would happen. I have a sneaking suspicion with 34.5% of our voters being non-affiliated, this would have a really good chance of passing.
Thank you. Assemblymember Dickman.
Thank you, Madam Chair, and thank you for being here. I think kind of based on what you just said, you answered one of my questions, and that was, do you envision nonpartisans being able to run in primaries?
Steve Yeager for the record. So I do not. I mean, the partisan primaries would remain the same. So there's a Democratic primary, there's a Republican primary. Nonpartisans can get into the general, right? But they have to get signatures. It's a whole different process. So this would not allow them to actually run in primary elections. They would simply be able to choose. I want to vote the Democratic ballot. I want to vote the Republican ballot, or I want to vote the nonpartisan ballot, which was what they have now. So I should clarify, I mean, if it's a nonpartisan office, they could run for it. If it's Justice of the Peace, District Court, that's already open, to nonpartisans, but they would not be able to run in a partisan office.
My quiet voice. In the past number of elections, we have seen a lot of opposite parties getting involved in the primaries of the other parties, where they have tried to select the least electable general election candidate. So can anyone request the ballot of their choice, or is it just nonpartisans who can request the ballot of their choice? And will this make it much more expensive for candidates to run?
Those are 2 very distinct questions. Yes. with different answers. And remind me what your first question was, because it's been a long day.
About the opposing parties getting involved in the primaries of...
Yeah, so no, the only thing this bill does is it allows, you have to be a non-affiliated, so either nonpartisan or no party affiliation. I know there's some other bills going through that maybe instead of calling folks nonpartisan, we're just going to call them no party, but you haven't selected a party. Those are the only people under this bill that would be able to choose to vote in either a Democratic or a Republican primary. So you can't, if you're a Democrat, you can't ask for a Republican ballot. That's not possible. And again, the nonpartisans they can basically do four things. They can vote in a nonpartisan ballot, a Democratic ballot, a Republican ballot, or they cannot vote at all, which, by the way, that's what a lot of them do in the primaries because there's not a lot of choices on their ballot. So that's question number one. And, you mentioned political parties messing in other candidates and other partisan primaries. That generally seemed to happen to me to be on the advertising front, right? Where you have you have some political activity where Republicans or Democrats are sending mailers in support of someone on the other party because they're hoping to advance somebody weaker in the general election. I mean, we can sort of debate whether that's effective, whether that's a good use of your money. I have not seen, since I've been in politics, any sort of real concerted, successful efforts to get party members to register as a different party and then go try to affect the outcome. Because, if we're being honest about it, if you're a tried and true Republican, you're not going to go register as a Democrat to vote in a primary, and vice versa. It's just anathema to your existence. So I don't think that's a concern that I have. The question about, is it going to cost more? I think it just depends what kind of campaign you run, right? But to the extent there are nonpartisans who want to participate in your primary, those are voters that you're going to want to be talking to. So perhaps it costs more, but I think that's a question really for the voter, right? And every district is a little bit different. I know probably when I run into primary, it's different than when you run into primary. Our general elections look different because of the makeups of our district. But I do think it will have the benefit that as a candidate in a primary election, you're going to have to try to appeal to a greater segment of the electorate, especially in districts that are very heavily Democratic or very heavily Republican, where the primary really is the race. I think that's a good thing to have to appeal to a wider base of the electorate. I understand there may be there may be countervailing viewpoints there, but really in this building we try to reach consensus. We try to reach out to folks and bring people together. So if an outcome of doing this is that you have to appeal to a little bit more of a broader audience, I think that's good for our democracy.
Thank you, and thank you, Chair.
Thank you. Next, we have Vice Chair Gonzalez.
Thank you so much, and thank you so much for presenting this. As a Sagittarius, I very much struggle with change, so I can understand that. This is something that our community will struggle with going forward. But I was curious if you could speak to how this has been implemented in other states. I know you referenced Arizona for the last, I think you said 20 years. Are there any other states that operate this way?
Steve Yeager for the record. It's hard to paint with a broad brush because different states do operate in different ways. In some states, if you go, you're non-affiliated and you want to vote in a partisan primary, they actually register you as part of that party. So there are states that do that. Illinois, I know, is one that does it that way, where you basically show up and you pick the ballot you want to vote in. This is based off the Arizona model. They have been doing it for 20 years. And as far as I know, they have not had issues in Arizona. It has worked well. I've talked to folks in Arizona. 20 years is a long time to get used to something, but they're used to it and it works for them. Nevada is very much like Arizona in terms of the demographics of our state, in terms of how much of a swing state we are. So that's the one that we're modeling this off of. I'm sure there are other states, but I don't want to get too far down that road because I think every state is a little bit different. But this is the Arizona model brought to Nevada.
Thank you so much. I appreciate that.
Next, we will go to Assemblymember Cole.
Thank you, Chair. So I have just a couple of questions, and they're more of a technical nature, because recognizing that any of these bills that we have before us could become law at some point, right? So I just want to make sure that language is good. So in your Section 1, subsection 1A, you talk about the method that somebody would request on the internet website of the Office of the County Clerk. And so my question is, I'm not sure that every county clerk has a website in which they could do that, and I'm sure you don't want a fiscal note of some kind. There are multiple ways, including even Secretary of State's office, for you to be able to request a mail ballot. So you might want to just strike after request, right? They can request it in whatever mechanism is available. And then the second question that I have is on A and B, you're giving them two choices, right? Like they can make the request 14 days in advance, or they can do it in person. But just walking down a scenario, right? I'm going to throw a hypothetical at you. So you have a person who makes the request for a Republican ballot, but they don't actually vote it. And they go to the polling location. Maybe they bring it with them, maybe they don't, maybe it's an affidavit, but they then request the Democrat ballot. Are you saying that that's not permitted based on subsection 2 of that they can only ask for one? Thank you.
Steve Yeager, for the record. Appreciate your suggestion on the first part of that. I'll get some clarification on whether each clerk has a website. I know they've been doing some good work integrating with the top-down voter registration system, so that might take care of that. So a quick note on subsection A, just a reminder, in the amendment, we're changing that from 14 days to the language that's in Assembly Bill 148, so it would be the 7th Monday before the election. So we are backing that up quite a bit. And here's how I envision it working. If you request a ballot, say you're a nonpartisan, you request a Democratic mail-in ballot, you do it within the time frame here, that's the ballot that you're going to get. Now, you could fill it out and put it in the mail, you could put it in a drop box, or you could do nothing with it, which happens sometimes, right? And people show up then on election day. So I don't think there's a prohibition from a nonpartisan saying, asking for a Democratic mail-in ballot, but then never doing anything with that ballot and showing up on election day and saying, I want to vote the Republican ballot. I think that would be fine under this bill. Obviously, there needs to be a check there, just like there is now with mail-in ballot, that you're not voting twice, right? Which is why it's important that that ballot will be individualized to you under all the barcodes and things that they have today. But I don't think that would be prohibited here. What would be prohibited is voting twice. Voting two different ballots would continue to be illegal and would be prosecuted. But I think that would be acceptable under this. And, the reason we wanted to back it up, of course, is they've got to do some processing with that. So if you change your mind, then it just means you have to actually go in person during early vote or on election day, and you could vote the same ballot you requested, you could vote the other partisan, or you could vote the nonpartisan ballot.
So in subsection 2, you've got a registered voter may not request a mail ballot or ballot in a primary election for more than one major political party. So that was my...
Yeah, Steve Yeager, for the record. You would not be able to change your mind and say, I want the Democratic mail ballot, and then 2 days later say, I want the Republican mail-in ballot. If you change your mind, you're going to have to go in person and vote. So that's what that was intended to do. So you don't have two different mail ballots. I mean, essentially, I don't see a scenario where you'd ever have 3, because you're going to make that election. If you don't make an election, you're going to get the nonpartisan one sent to you. But we don't want a situation where someone has 2 different mail-in ballots in their possession, because I think that would cause problems.
Thank you. Next, we have Majority Leader Hedege.
Thank you, Chair, and thank you so much for bringing this bill forward. I really appreciate it. I carried a very similar bill in 2019 to help everyone have the ability to have their voice be heard, because there is a large population of people who don't get to participate in the primaries. And one of the things I learned is that this isn't unique, and it hasn't been a unique idea for a long time. There's states who actually don't even have people register for parties. You have to be a candidate, you have to register for a party to run, but voters just register to vote. And in some states don't register for a party, but when it comes to the primaries, they just request which primary ballot they want to participate in. In 2019, I carried a very similar bill that didn't get anywhere, and one of the things I learned in doing my research was that in the session before then Assemblymember Ira Hansen carried a very similar bill, and I actually used some of the documentations from his bill presentation, which was really interesting, because he showed in his 2017 hearing that there was actually 21 elections that took place in the state of Nevada where there was only one single candidate on the ballot for 21 elections. And in 20 of those elections, I actually have it, in 20 of those elections, 20 of them were Republican only. And these are his words from his minutes. In other words, the Democrats and independents in 20 different elections did not get to vote for the person who now represents them. He went on to say, we spend a lot of time in this place trying to get people to turn out the vote, and we talk about giving felons the right to vote and other similar things, but this bill, but because of a previous bill that was passed, we disenfranchised virtually everyone from participating in primaries if there is only one person running. And we talk a lot about expanding access to democracy, and that's what this bill does. Because in some elections, like Senator Hansen pointed out, there is only one party running sometimes. That means that every single other person in that district, whether it's a county district, an assembly district, a Senate district, never gets to participate in that election. And we are simply opening the window to a few more people to have their voice heard. So thank you.
Thank you. Steve Yeager, for the record. Could you send me those minutes in case I get over to the Senate? Because I think those might be useful to remind Senator Hansen of those words. But no, I remember that. I mean, Senator Hansen was right. If you have a ballot, it's only Democrats file, only Republicans file. Everyone else doesn't get a chance to participate. Now, we can argue, well, if you want to participate, you should register as a political party. I get that argument, but the truth is people aren't going to do that. We know that it's human nature. So I appreciate you bringing that up, and you gave me a good opportunity. I did want to get back to Assembly Vice Chair Gonzalez's question about how many states sort of use this model of allowing non-affiliated voters. So I did have a list here. So Arizona is the one I talked about, but Colorado, Maine, Massachusetts, New Hampshire, North Carolina, and Rhode Island all have a very similar setup to this, where a non-affiliated voter can choose to vote a partisan ballot without having to actually register with that party.
Thank you. That's great to know how many states are doing it. Committee members, any last questions? Okay, Assembly Member Hibbets, okay.
Ouch. Thanks, Chair. So my question, Speaker, is Section 1, Subsection 1, registered voter who designated on his or her application to register to vote no affiliation with a political party may vote in a primary election. It goes on to tell you how you do that. So what about somebody registered as Green Party or Independent American Party? They are registered with a party.
Steve Yeager, for the record. Good question. They would not be able to vote in another political another partisan. So this only is truly non-affiliated, which right now is nonpartisan or no political party. And I think there's a bill to change that, to consolidate it into something like no political party. But yeah, if you're Green Party, you know, you're not going to be able to say I want to vote in the Democratic or the Republican primary. And same if you're Independent American Party, you've chosen a party. You can vote in that party's primary, although we know, practically speaking, they don't have a primary. It's only the two major ones. So it's just for nonpartisan, no political party.
Okay, thank you, Assembly Member. That was a good question. Okay, thank you. So with that, we will start our testimony, and we will start with support. So if you are here for support of AB 597, you can start filling the tables. I will read the call-out number. It is 669-900-6833, and the meeting ID is 821-2679-8649. I will remind everybody here that we have 2 minutes. You can state and spell your name for the record, and it's very important that our comments stay to the contents of the bill and not the bill presenter. So we will start. We have our Secretary of State here.
Good evening, Chair, members of the committee. Cisco Aguilar, Secretary of State, for the record. I'm just here to testify in favor of this bill. I think as we've seen over the last couple years, the number of Nevadans registering as nonpartisan has increased significantly. They are now the major political group in the state of Nevada. And to give them a voice, to include them in the process, I think is a very commendable thing. So we will do everything we can in the Secretary of State's office to accommodate this legislation and make sure that Nevadans have a voice. It's about access. So thank you.
I'm Eric Obermeyer, ERICHOBERMAYR. I'm from Silver City, and I'm here to support AB 597. I ran for Assembly District 39 in the last election. I didn't win, as you could easily guess, but I did run on a similar proposal to 597, which would open the primaries to nonpartisan voters. And I can say that in all our canvassing and door knocking, we didn't get a single negative response to the idea. The problem AB 597 addresses is that nonpartisan voters, the largest single voter bloc in the state, can only participate in half the electoral process. They can pick from a list, but they don't have a say about who's on the list. AB 597 obviously reduces the influence of political parties. but I believe the benefits of opening the primaries to nonpartisans are worth it. It offers candidates the opportunity to appeal not only to their fellow party members, but to a group of voters who, by definition, look beyond party labels and judge candidates and their ideas on their individual merits. Any law which opens elections to more voters strengthens our democratic republic, and I hope you vote to approve AB 597. Thank you.
Thank you. Seeing no others in Carson City, we will go down to Las Vegas for support.
Good evening, Chair Mosca and Chair Orenshall and members of the committee. My name is Christian Solomon, S-O-L-O-M-O-N. I'm the West Regional Director of RISE, a Gen Z-led civic engagement and advocacy organization for college students and youth. Speaking in absolute support for AB 597 because political parties should be competing for nonpartisan voters. Nonpartisans make up the bulk of Nevada's electorate and are also paying for the current primary process that excludes them. Democracy is truly working when we measure our process by how many diverse voices we include, not exclude. I want to thank Speaker Yeager for introducing this very essential electoral reform policy and strongly urge you all to support it. Thank you.
Thank you. Seeing no others in Las Vegas, AVH, please open the phone line for support of Assembly Bill 597.
To testify for support of Assembly Bill 597, please press star 9 to take your place in the queue. Again, press star 9 to take your place in the queue.
Good evening, chairs and committee members. I am the former Assemblywoman Clara Thomas, C-L-A-R-A-T-H-O-M-A-S. I am supportive of AB 597, a quasi-open primary bill. This bill will have a direct impact for Nevada's 36% nonpartisan registered voters. The ability to participate in Nevada's primary election process. AB 597 is a start to fulfilling the right that the U.S. Constitution gives the U.S. citizens to cast a vote in U.S. elections. The nonpartisan voters have been left out of this process and the primary elections for too long. The time for change is now. Not quasi-open primaries in Nevada, but full open primaries for all citizens in the great state of Nevada. It is my hope that Nevada, in the future, will have open primaries without stipulations. I want to thank you, chairs and committee members, for listening. Thank you so much.
Thank you. Next caller.
Good evening, and thank you, Chair and committee members. This is Evelyn, E-V-E-L-Y-N, Pacheco, P-A-C-H-E-C-O, and I am an Army veteran, and I'm asking that you pass and highly support AB 597, and I ditto what Clara Thomas just said. Thank you.
Thank you. Next caller.
Chair, we have no additional callers for support at this time.
Thank you. With that, we will move to opposition to Assembly Bill 600. Don't forget, we will have 20 minutes in this time block. State and spell your name for the record. And we will start here in Carson City, and then we will go to Las Vegas. You may begin when you are ready.
Good afternoon, Chair and Committee. My name is Joshua Skaggs, and I am the Legislative Affairs Director for the Nevada Republican Party, here today in opposition to AB 597. The Nevada Republican Party firmly opposes any legislative attempt to impose an open primary system on our state, an idea the voters clearly rejected in the 2024 election. The presenter indicated that having party principles debated by those not part of the party doesn't threaten party integrity. We disagree. People are members of a party because they have shared principles and values, and those who deliberately choose to not be a part of the party shouldn't be part of the party's candidate selection process. Less than 1/3 of nonpartisan voters vote in the general election. Since any who wants to can already vote in the primary simply by changing their voter registration same day, we've always disagreed with the concept that these voters are disenfranchised. We are concerned that Speaker Yeager introduced AB 597 at the end of the legislative session, despite saying before the session started that he would not introduce such measures. The timing blatantly circumvents public debate and meaningful scrutiny. This end run around the normal deliberative legislative process is profoundly disrespectful to Nevada voters who just months ago rejected a policy now being rushed through the legislature. Our chairman, Michael J. McDonald, noted as a part of his written testimony on Nellis that, quote, nonpartisan voters already have a pathway to the general election. They may support independent candidates, create their own parties, or add candidates to the ballot by petition, but they do not and should not have the authority to shape the candidate slate of a political party that they refuse to join, end quote. We urge you to reject AB 597, and thank you very much.
And let's make sure we keep our comments to the bill itself. Thank you. Next.
Good evening, chairs, assembly members, and senators. My name is Nancy Carlson, C-A-R-L-S-O-N. I believe AB 597 circumvents the will of the voters who voted in 2024 in opposition to open primaries via the No on Measure 3 effort. The purpose of open primaries is to enable voters to vote for any party during the primary. This was implemented in my former home in the state of California, and they are now a one-party state. Open primaries result in minimal checks and balances, never a positive outcome of the legislative process. Why vote against AB 597? True open primaries can undermine the principles of ideological consistency by allowing voters from outside a party to influence its candidate selection. Political parties are private associations protected by the First Amendment, and they should be able to conduct their primary nomination as they see fit. The ability to vote for another party already exists in Nevada primaries. Current Nevada voter law allows voters to change their party on the day they vote with the same electronic form used for an address change, an RU, not an same-day registration form, which is used to register new voters. The number of people who changed parties during the June 2024 primary was very low. I was there, I worked the election. This party change on election day takes seconds. We are not disenfranchising voters. To say that nonpartisan voters are disenfranchised is not accurate. To make this process any simpler risks potential intentional damage to the major two parties. While true open primaries aim to promote inclusivity, they risk undermining party integrity by enabling voters from another party to harm a candidate.
Thank you, Ms. Carlson. You are at 2 minutes, but you can submit your written testimony to the committee, please.
Thank you for the chance to speak.
Thank you.
For the record, I'm Bruce Parks, B-R-U-C-E-P-A-R-K-S. I represent the Washoe County Republican Party as their chairman. We are adamantly opposed to this bill. This bill essentially establishes open primaries for Nevada. Open primary by any other name is still an open primary. We Nevadans just voted overwhelmingly against just such a measure when we said no on question 3. And yes, we considered both aspects of question 3 when we said no. We see this for what it is, an attempt to circumvent the will of the people. Those that argue in support of open primaries maintain independents and nonpartisan voters have no voice in primary elections. This is patently untrue. Those voters not affiliated with either the Democrat or Republican parties still receive a ballot and can vote for any nonpartisan candidate which is in alignment with their choice to be independent of the two major parties. It is absolutely antithetical to the democratic process to allow persons not registered with a particular party to vote in that party's primary. Independent nonpartisan voters choose to separate from the major parties and are free to run their own candidates, which they seldom do. They should indeed be unaffiliated. It is a choice. Choices come with consequences, as it should be. Same-day registration is law here in Nevada. In the event a voter wants to vote for a candidate affiliated with a major political party, they're free to change their registration accordingly. That being the case, this bill is redundant to existing law. An additional concern is the possibility nonpartisan voters would be able to influence the outcome of the major political party selection of their preferred candidate during primary voting. A large block of nonpartisan voters could organize to effectively change the outcome of a primary election. A conspiracy theorist would probably conclude that that's the purpose of this bill. I urge you to please consider the ramifications of this bill and the impact it will have on our democratic process for years to come. If in the event a ballot measure...
Thank you, sir. You are at 2 minutes, but we hope you will submit your testimony. Thank you.
Madam Chair, my name is Sean Meehan, and I'm testifying on my own behalf today. I've been a member of the Nevada Republican Central Committee for 12 years, and for 10 years chaired the Resolutions Committee. I say that to point out that I have insight into how things have really worked with parties. The sponsor said that independent voters are unaffiliated for a reason. I'll let that one sit. He said 50%, that's power. There currently are ways for them to exercise that power. And I found it interesting that he said that if you're a diehard Republican, you're not likely to re-register as a Democrat and pick their candidate. You ever heard about Operation Chaos by Rush Limbaugh back in the day? That was a thing. Supreme Court has litigated the principle of free association of political parties. Tashian v. Republican Party of Connecticut, so the United States Supreme Court struck down a state law that prohibited, where a party was prohibited from inviting independents into their primary. They said it unconstitutionally burdened the party's associational rights. Klingman versus Beaver. The U.S. Supreme Court held that a semi-closed primary system recognizing the political party's right to decide whether and how non-members may participate. It goes on. There are more. Each of these judicial opinions affirms a core constitutional truth. A political party has the exclusive right to define its membership and to control who selects its leaders and nominees. First Amendment of the U.S. Constitution protects the right of free association, not just for individuals, but for political parties as private associations. Imagine somebody demanding to help choose your pastor without ever going to your church, accepting or understanding its beliefs, or attending its services. That's what AB 597 would do to political parties. Support the Constitution, uphold the freedom of association, as the U.S. Supreme Court has repeatedly affirmed. Please vote no on Assembly Bill 597. Thank you for the time, Madam Chair.
My name is Catherine Ingham, Catherine-Ingham, and today I am here on behalf of the Nevada Federation of Republican Women, and I have a letter to read. Dear Chair and committee members, thank you for allowing me to read our letter on behalf of the Nevada Federation of Republican Women regarding our opposition to AB 597. The Nevada Federation of Republican Women represents 18 clubs statewide and more than 1,500 members. On April 13, 2024, the Nevada Federation of Republican Women unanimously adopted a resolution opposing open primaries. Our concern with AB 597 is that it proposes changes to Articles 5 and 15 of the Nevada Constitution. Furthermore, in the 2024 election, Nevada voters overwhelmingly rejected the concept of open primaries. We urge you to respect the will of the people and vote no on AB 597. To be absolutely clear, we strongly oppose AB 597 and respectfully request your no vote. Thank you.
My name is Catherine, Kathryn, Vineyard, Vineyard, and I am here as a private citizen. I was involved in Prop 3, ballot measure 3, and I have to tell you, people totally understood that an open primary was going to take away the rights of that specific party. It wasn't misunderstood that there was going to be a jungle. Nobody was confused about it. We did not want, and we voted against having open primaries in ballot measure 3. The thing is, Assemblyman Yeager said that this is a way for us, it's a bill about our trust in our system. And in fact, it's just the opposite. It is eroding our faith in our system. A voter, when they vote, they believe that their vote is going to count more than a year. And it makes no sense that we're trying to turn that around. And to say that somebody's going to come in and propose a jungle primary again, well, that was outside influence that was pouring money into our state in order to make that happen. We need to be stronger about that and not accept money from out of state when they're trying to mess around with our own system. I also heard that we don't spend any time trying to register people. We have registration drives, and it's up to us to try to convince nonpartisan voters to join our party. We do that all the time, and that's part of what our effort is going to be, to get them to decide that they appreciate the values of the Republican, in this case, the Republican Party, and join our force. It's their choice how they're going to vote, and we want them to be able to make a good choice based on our information. But the thing is, what I keep on getting, nobody's talking about how all these people.
Thank you. We are at 2 minutes, so we appreciate you. You can.
They could vote in the general.
You can put it into writing to the committee. We have about 10 more minutes left in this block, so I'm going to take the 2 in Las Vegas, and then we'll come back up here in Carson City. So down in Las Vegas, if you'd like to begin.
Chair and members of the committee, my name is Jill Douglas, Douglass. I rise in strong opposition to Assembly Bill 597. This is not good public policy. Just months ago, Nevadans overwhelmingly rejected the ballot initiative that would have upended our election system. The vote was loud and clear. Nevadan voters do not want open primaries, yet here we are facing another attempt to override the will of the people, this time through legislative maneuvering rather than through democratic consent. I'm also worried and not addressed is that this creates another unfunded mandate, as certainly there would be expenses required to mail out ballots to this segment that doesn't currently get them today. AB 597 seeks to allow nonpartisan voters to cast ballots in the partisan primaries, but party primaries exist for a reason. That is how Republicans choose Republican candidates and how Democrats choose Democratic candidates. It's not exclusion, it's definition. No one should be able to hijack a party's internal process to sway the outcome of a general matchup. It's very simple. If I belong to XYZ club, only people of that club have voting privileges. A member of the ABC club cannot come and vote. Allowing nonpartisans to vote in a party's primary waters down party identity, undermines grassroots efforts, and allows the door to political gamesmanship where operatives can cross over to skew the results. If nonpartisan voters want to participate in a party primary, they are free to join the party. And I have been a poll worker, and in fact, many voters do show up and do change their votes the day of voting. This bill is not about access, it's about control, it's about blurring lines, weakening party voices, and silencing the rank and file voters who have built their party from the ground up. Please respect the voters, respect the process, and more importantly, respect the results of the 2024 election. When Nevadans said no to this kind of manipulation, I urge you to reject AB 597 and help uphold the integrity of Nevada's primary elections. Thank you for the opportunity.
My name's John Sarpalas, that's spelled T-S-A-R-P-A-L-A-S. I am president of Nevada Policy Research Institute, an organization which worked very hard to defeat ballot question 3. But I'm here with a whole other twist. Why are the minor parties not allowed in the primary process? If we're here to offer diversity and opportunity, why do we exclude them? Why is it only the major parties? Because the major parties had the clout to force the primary system on the taxpayers. What about the taxpayers here? We will have to mail more ballots. There will be more cost to this. And you, as a candidate in a primary, and often non-incumbent candidates don't have a lot of money to run in a primary. And now you're going to have to mail to the independents, figure out how to reach them, social media, whatever it is. You're upping the costs, and you're keeping this limited in certain areas, such as these minor parties. So I'm going to suggest, why don't we eliminate primaries? Go back to the caucus, go back to conferences, let the parties pay their own expenses. Don't dump that on the taxpayers, which we have done with the primary system. So with that little thought and completely new thought to all of this, I hope you will oppose AB 597. Thank you.
Thank you. Seeing no others coming to the table in Las Vegas, we'll come back to Carson City.
Chair and committee, thank you for the opportunity to talk to you tonight. I'm John Crawford, Jon Crawford, and I am the chair of the Douglas County Republican Party. And I ditto all the opposition testimony you've heard tonight, renders most of mine redundant, but I'll proceed. Open primaries to some may sound like a fair idea, but it would surely undermine the integrity of Nevada's political process. Nevada already has one of the most flexible voter registration systems in the country. You can change your party affiliation quickly, often within minutes, online or in person. If someone wants to vote in a Democratic or Republican primary, they simply update the registration. After the election, they're free to change it back. It's that simple. Open primary isn't needed to ensure access. It's already available. The true agenda behind AB 597 is clear. What open primaries do is allow those outside of a political party to influence a party's nominee. People they choose to register nonpartisan, as stated previously, because they don't identify with the values and ideologies of the Democratic or Republican parties. And yet they want to influence the leadership of those parties. It just escapes the logic. The intent is to render candidates that no longer reflect the values of their party. Party primaries are meant for the party members to choose their leaders. If someone wants a more prominent voice in that party, they can join the party. Let's keep our political parties true and clear in their values and representative of their members. I respectfully urge you to reject AB 597. Thank you.
Good evening, everyone. My name is Joy Trushinsky, Trushenski. I'm a non-paid lobbyist for conservative causes, and I am a Navy veteran. Please vote no on AB 597, pushing open primaries. Political parties are private entities protected by the First Amendment, and only their members should determine who their candidates should be. As a Republican, I do not want someone who is not a Republican to vote in a Republican primary, and I don't want a non-Democrat to vote in a Democrat primary. Democrat values and Republican values are different. We have a two-party system in this country. We have two major parties, the Democrat Party and the Republican Party. Voting for the best candidate in one's party is critical. Anyone who is an independent has the opportunity to change their affiliation and participate in a party, but independents do not involve themselves in the political process in either major party unless there's a major election coming up. I support independents becoming more involved in one of the major parties. I prefer a Republican, of course, but I do hope that independents will come to know the candidates of both major parties, because we do have a two-party system in this country. Please vote no on AB 597. Thank you for your time. God bless.
Thank you. We just have a few minutes left. Go here and we'll open up the phone line briefly.
Thank you, Chair Mosca and Orenshaw. My name is Kathleen Celine. I'm here today on behalf of the Churchill County Republican Central Committee in opposition to AB 597. I'll be brief. Closed primaries are a vehicle for party members to choose their candidates, whichever party that may be. They should not be open to non-party members, and requiring that someone be a party member to vote in the primary is not disenfranchisement. They still can vote in the general. Allowing non-partisans to vote in open primaries could misrepresent the will of the people who are party members and want to vote in that party. Non-partisans should not influence the candidate selection process of the party that they've chosen not to join, really. Primaries should be for party members only. That's it. Thank you for listening. Please vote no on AB 597.
Thank you. AVH, let's open up the phone lines for opposition to AB 597.
If you would like to testify in opposition of Assembly Bill 597, please press star 9 to take your place in the queue.
Hello, my name is Cynthia Perrine, CYNTHIAPERINE. I am in opposition of AB 597, and I ditto the very astute comments in opposition that precede me. In addition, I would just like to make the point that there is no hard data to support that independents actually want this. The sponsor repeatedly said, I think, or I have a sneaking suspicion that independents will take advantage of this bill. The lack of hard data, to me, appears to be a bill looking for a problem that is not there. In addition, it is only the independents that enjoy the privilege of changing or asking for an alternate ballot. And it is not afforded to other parties, such as the Green Party, as was brought out by another person. This is antithetical to the democratic process. For these two reasons, I would suggest that the committee vote no on AB 597. Thank you.
Thank you. And we did actually go a little bit over of our 20 minutes. So if you were waiting on the phone line or in Las Vegas, please submit your testimony to the committee. We will read that and we will look at it. So with that, we will move to neutral for testimony in Assembly Bill 597. Same thing, we will do 20 minutes. State and spell your name for the record.
Good evening. Thank you. Amy Bergens, Douglas County Clerk Treasurer, BURGANS. I'm here representing the rural county clerks. I wanted to thank Assemblymember Cole, who seems to have stepped out for a minute. It's been a long evening, so I wanted to thank her for her comments earlier, and I'm going to just reiterate them, and I do plan to submit hopefully a conceptual amendment, if I can get it written tonight, about the concerns that we have just in the implementation of this bill. In Section 1, under subsection 1A, where it says submitting a request not later than the 7th Monday before the election to the county clerk on the internet website of the office of the county clerk. The rural county clerks do not have a mechanism by which to submit a request via their internet website. I would love to see that just say submit a request, and therefore the Secretary of State and the county clerks can get together and just determine the best way that requests can be submitted for the ballot. Limiting the way by which someone can request this really is, I think, not the intent of the legislation. So I'm asking for that to be revisited. And then same section, section 1, number 2, where it says a registered voter may not request a mail ballot or ballot in a primary election for more than one major political party. I know that Speaker Yeager did speak to the intent behind this being that They could request it, say they requested a Republican and received that mail ballot, but then came in person and wanted a Democrat. I do believe that the way that this legislation is written should be clarified if the intent is for them to be eligible to then request a second party. It seems restrictive to me,
Thank you,
and
Clerk
I'm
Burgess.
concerned.
We do appreciate you, but you're at 2 minutes.
Thank you so much.
Doug Goodman, D-O-U-G-G-O-O-D-M-A-N, founder, executive director, Nevadans for Election Reform, Chair Mosca, Chair Orenshaw, members of the committee. Many of you know I've been advocating for open primaries and ranked choice voting since 2013. We had a bill in 2015 introduced by 2 Republican senators, so you may be surprised I'm testifying in neutral on AB 597. I would like to thank the Speaker for recognizing the fact that voters have been abandoning 2 major political parties for quite some time, and that for almost the past 2 years, voters registered as nonpartisan have been the largest segment of voters in Nevada. It is important to note that the shift towards nonpartisan began long before automatic voter registration was implemented. AB 597 is a start, but it's far from ideal, hence my neutral position. This bill replaces a semi-closed primary with a semi-open primary, allowing voters registered as nonpartisan to request the partisan ballot of one of the major parties without having to change voter registration and vote for only candidates of that party. Voters registered in minor parties are excluded. Allowing nonpartisan voters to participate in the major party primaries is a small start. However, I question how effective it will be, as the dislike to associate with a political party is strong, especially among younger voters. During the last election, many in opposition to Q3 had no issue with the nonpartisan open primary piece. The measure lost because of the ranking element. By placing all candidates on one ballot and allowing a voter to vote for any candidate, regardless of party, would overcome having to select a party and the question of non-party members selecting a party nominee, as the opponents rightly point out, that they are private organizations. If they want to keep it private, then they should pay, not taxpayers, all taxpayers. Democrats pay for the Republican primary.
Thank you, Mr. Goodman. You're at 2 minutes, but I know you will submit it to our committee.
I already have. Thank you very much, Chair.
you.
Appreciate it.
Thank you to the committee. My name is Kimmy Cole. That's K-I-M-I, last name C-O-L-E. I am speaking only on behalf of myself and people who may agree with me. I appreciate the fact that the body is paying attention to the steadily increasing number of nonpartisans in the state. Looking at this proposed legislation, I'm still attempting to figure out if it is a small step forward or just a token lateral move. On the surface, it resembles putting a new and improved label on a box and product that has been recycled repeatedly with few, if any, tangible improvements. It is still discriminatory toward rural areas, offering no realistic choices of options. Many I know would like to have a choice.
And I'm sorry, if you oppose any part of the bill, it's actually opposition. So if you will submit that to our committee, we will include it towards opposition because we've ran out of time for opposition. So we'll go to the next neutral.
There we go. Good evening. My name is Aisha Goins. I'm here as the first vice president of the NAACP on behalf of the president who had to leave and catch a plane of the NAACP. We represent over 600 members, 15 executive committees. We're the largest, the oldest, the baddest, and the boldest, the most loved, the most hated, the most feared, and most revered, the most cussed and the most discussed civil rights organization in the USA. We just wanted to lean in and say that we typically would take a position. We will not be, because we haven't had an opportunity to present this bill to our executive committee. And also in the NAACP, the association, we have a long time history of weighing in on voting issues, but we cannot do that without presenting this information to our executive committee for them to form a decision. And so we're just going to be neutral. Thank you.
Thank you. And seeing no others neutral here in Carson City, we will go down to Las Vegas.
Yes, my name is Ed Euling, EDUEHLING, and I'm one of those people who does not want to be identified as a Democrat and certainly do not want to be identified as a Republican. I am registered nonpartisan. And I appreciate very much that this is finally being discussed here in the legislature. And congratulations for Mr. Yeager for bringing this forward. And to all the people that have testified. It's great that we're finally discussing it. However, there are two aspects to this. One, to this largest group having a voice in the politics of the state. There's the aspect of being a candidate, and there's the aspect of voting in the election. In terms of being able to be a candidate, the Secretary of State has taken it on himself, or took it on himself in the last election, to prevent nonpartisan people from getting on the ballot. Look at what happened to JFK. Look what happened to Jill Stein. Look what happened, and I'll tell you about my particular case, that the remedy or to how to get on the ballot for a nonpartisan is to gather signatures. The Secretary of State denied 80 signatures of mine just because the address was different from the address that the person is currently living. They still lived in the same district, but the Secretary of State took it on himself to keep me off the ballot.
Thank you, Mr. Euling. You are at 2 minutes, but please submit your testimony to the Secretary and our committee.
In order to get
so
my
we will go to our
$500
next
back.
person, please, down in Las Vegas for neutral.
Greetings, Commission. Greetings, Committee. Thank you, Chairs. My name is Ben Pennington, BenPennington, speaking for myself today as private citizen and as a registered nonpartisan. And I want to talk to you about my first three elections that I voted in, which were in the state of Indiana, a state that has open primaries, sort of. Indiana doesn't register people by party. You just kind of go in and pick a ballot. And I'm going to talk about the 2012 election. There were 4 candidates running for U.S. Senator. Richard Murdoch, the incumbent Richard Lugar, both Republicans, Libertarian Andy Horning, and the eventual winner, Joe Donnelly. I thought long and hard about how my mom was going to go vote. And so I went and I picked the Republican ballot. And I voted for the worst candidate, Richard Murdoch. And as fate would have it, his mask fell off during a debate, and Joe Donnelly won. Choices have consequences. If this is a bill if this committee wants to give me the ability to do those games again here in the state, go for it. But just remember, choices have consequences. That's all. Thanks.
Thank you so much. And with that, we will open up the phone lines for neutral. Please, AVH.
To testify in neutral, please press star 9 to take your place in the queue.
Hello, my name is Brandon Moody, BRANDONMOODY. I'm speaking as a private citizen in neutral of this bill. This is a shorter measure of an open primaries, to be clear, and to make that a very important point when the legislature considers this. I also want to speak to the integrity and the incentives in elections and looking at the demographic change as a reflection. And I do not believe that, whether this bill passes or not, that political parties will be diminished or strengthened. I just feel the integrity and the incentives will be more clear for all voters either way. And I'd like to see more, but I am in neutral of this bill. Thank you.
Thank you. AVHX caller.
Chair, we have no additional callers wishing to provide testimony in neutral.
Thank you so much. And with that, we will invite Speaker Yeager up for any closing remarks.
Steve Yeager for the record, Chair Mosca, Chair Orenshall, members of the Joint Committee. I want to thank you for hearing this bill this evening. I know we're late in the session and these days are long. And I want to thank those who participated in the hearing. I'm always up for a spirited discussion, and I think that's what we got tonight. And your questions were obviously fantastic. I want to be clear on a couple of points. I was a no on question 3. I was a no on question 3 in 2022. I was a no on question 3 in 2024. You can find some statements from me. I think I did some videos opposing it. I thought both concepts were bad in that question. What you have in front of you is not in question 3. It's a different concept of a concept of an open primary. I want to acknowledge, Chair, that I think the concerns raised by Assemblymember Cole and by our Douglas County Clerk, I think those are legitimate concerns. And so whatever this committee decides to do with this bill, I'm committed to make sure that that language works. I've had some communication with other clerks who don't read the language the same way, but it's important that we get it right. So regardless of what this committee does, I'll make sure that we tighten up that language so there's no ambiguity there. Chair, I think as electeds, it is our duty to see the world not as it is, but as we wish it to be. Not to be stuck in old conventions of entrenched interests. If we're not going to lead, then the question is who is going to lead on this issue? And I think the answer there is those who seek to use their wealth to experiment in our elections in the Silver State. To me, that's not acceptable. And that's why I'm bringing this idea, Assembly Bill 597, to you this evening. So, Chair, with that, I would urge your support of the measure, and you all know where to find me in this building. So if you'd like to further discuss this, I'd be more than happy to do so. Thank you so much for your time, chairs and members of the committee.
Thank you so much. And with that, I will close the hearing on AB 597. With that, I will go to the last item on our agenda for our joint committee meeting. Our last item of business will be public comment. Each member has 2 minutes to provide testimony, and you can also provide the testimony in writing up to 24 hours after the meeting. Members of the public may comment on anything that is within legislative operations and elections, but not a rehearing of any of the bills tonight. So you cannot comment on things on the bills that we've already closed the hearings on. And finally, before we start, I'll remind everyone of the call-in number and ID. 669-900-6833, and the meeting ID is 821-2679-8649. We will start here in Carson City if anyone is here for public comment. Seeing none coming to the table, we will go down to Las Vegas for public comment.
Greetings once again, committee. Heard a lot from me today. So we're going to go back to Indiana 2012. There was the gubernatorial election that year, too. We had
Sorry, you
Mike
still have to
Pence.
state your name for the record. Go ahead.
Oh, my bad. Sorry about that. Once again, Ben Pennington, BenPennington. Sorry about that. Private citizen, nonpartisan. And I'm going to restart my timer. And
yeah, I actually don't
with that
start
being
the
said-
timer until after the names are said and spelled, so keep going.
Okay. Anyway, in 2012, Indiana had a gubernatorial election as well. We had Mike Pence, John Gregg, Rupert Boneham. I campaigned for Rupert Boneham that election. The only time I've ever campaigned for a libertarian. The only libertarian I've ever voted for. John Gregg was one of the few Democrats I've never voted for. You know, I consider myself a party member in terms of how I spend my time and how I spend my money. There are people who are in the audience in Carson City who I have spent my time for. I don't know if I'm going to spend my time with them again. With that being said, in Indiana in 2012, in that gubernatorial election, Mike Pence did not win 50% of the vote. Let's say, for example, that I'd have been allowed to rank my ballot. My second choice would have been John Gregg. For as flawed as he was still a second choice. But oh well. And thus we got Mike Pence, the only gubernatorial candidate from Indiana who didn't win a majority in 50 years. That's how you guys got a vice president. That's how we all got a vice president. In closing, I just want to say one thing. Ranked choice voting can be used by kindergartners in Ireland. It could be used here. Voters deserve more. Have a great day.
Thank you. Seeing no other public comment in Las Vegas, AVH will open up the phone line for public comment.
If you would like to provide public comment, please press *9 to take your place in the queue. Again, please press *9 if you wish to provide public comment.
Hi, my name is Katrin Ivanov, IVANO Frank, and sorry about that. It is very disappointing that the last 2 weeks of the last 2 weeks you guys suspend the rules that you should be following in order to create laws, and that it's allowed to bring in the 11-hour views where don't go through the regular way of us being able to vote and show on Nellies how much we don't like it or like it, depending on the law. In this case, obviously not. However, you had 2 other views that people didn't comment. You saved so much time from that, and yet we were not allowed to express our opinion, especially in a situation when this is brought in the 11th hour. And if there is any confusion, if the voters want it or not, why you don't bring it as a resolution and bring it for the voters to vote on it next time? Why are you taking that chance from the voters again in another view? This has been very disappointing, not just in this committee, but in other committees, that the people's voice have been ignored over and over and over again. I implore you to listen to us when you give us a chance to talk, because when you bring a bill in the 11th hour, a lot of people don't even know that bill is even brought up in order to speak. So I don't know, maybe when you make rules, you should follow them instead of suspending them. Maybe you should think about that. Thank you and have a lovely day.
Thank you, AVH. Next caller.
Chair, we have no more callers wishing to provide public comment.
Okay, thank you. So I have a reminder here before we go. Well, first I want to thank Chair Orenshaw and our senators for being here for a joint meeting. Assembly members, please do not go far. We are reconvening our regular meeting from earlier upon the adjournment of this meeting, and AVH needs enough time to reset and switch before we start. And our regular meeting will start in about 10 to 15 minutes. And with that, thank you again. Seeing no further business before us, the joint meeting is now adjourned.